office premise of Central Administrative Tribunal, inaugurated in Mumbai by the Honorable Chief Justice of India, D.Y. Chandrachud, marking the importance of judicial infrastructure with a vision of accommodating people with diverse needs, and also appreciating the government's contribution to support the building of new inclusive judicial infrastructure with promoting the digitalization all over the judicial system, which is also called the Nyay Ka Mandir, to inaugurate Nishtha Office Complex by the Honorable Chief Justice of India, D.Y. Chandrachud, in Mumbai, acknowledging the importance of the best judicial infrastructure. With this, we will take you to the address of the Chief Justice of India in Mumbai.
Honorable Judges of the High Court, I really thank all of you for rushing from court here to be with me this evening. Former Honorable Judges of the Bombay High Court, your presence has really moved me emotionally this evening, because all very dear friends with whom I have such old and long memories. The Advocate General of Maharashtra, Ranjit, Chairperson of Central Administrative Tribunal, all the other members, Vyas, Additional Solicitor General of India, office bearers of the Bar Association, members of the Bar. First and foremost, I would like to applaud the Chairman and the office bearers of the Central Administrative Tribunal for their efforts in securing this office space. My heartfelt thanks and appreciation of the work which has been done by the CPWD branch in setting up this office. As any Mumbaikar can testify, the troubles of securing spaces in Mumbai are well known. We just used this opportunity 15 minutes ago to judicially hold the Advocate General of Maharashtra to ransom by demanding that our dream of setting up the Bombay High Court in new premises is fulfilled at an early date. And like every good Advocate General, he owes his loyalty first to the High Court and then to the government. Talking about the difficulty of finding spaces, I didn't have that kind of a difficulty when I was a lawyer. I had a massive office when I was a lawyer. And my office was about 120 square feet. And in that 120 square feet, we all packed in half a dozen juniors, me, and ever so often my juniors would come into the chamber. And I later on realized that they would come into the chamber more for the air conditioning than for the exchange of ideas. I don't know what happened. We produced one Advocate General and a Judge of the High Court, and not to mention a senior counsel at the bar, or 3 senior counsel at the bar. I'm certain that this complex is an outcome of very dedicated efforts of everyone involved and also the cooperation of the government. Very often we forget the importance of the work which the government does in aiding and supporting the judicial infrastructure. I must say, in the interest of full disclosure, that events such as these inaugurations of new benches and new court complexes always make me feel nostalgic about my own time as a lawyer. That's why I began about my beautiful, the 120 square feet office. I had the great good fortune of appearing before the Central Administrative Tribunal when it was situated in the insurance building. I would go there ever so often, appear before the Central Administrative Tribunal. Later in my years as Additional Solicitor General, I went very, very often to the Central Administrative Tribunal. I am confident that the young members of the bar and the bench will put these additions to our courts and tribunals to great use. I am confident also that this office complex will add tremendous value to the working of CAT and the experiences of those approaching it. With that hope, I would like to address you briefly on an issue that is very close to my heart. That is the issue of accessible infrastructure and access to justice. The Central Administrative Tribunal was born out of the 42nd Constitutional Amendment. Many of you are much younger, some of you are older, and I'm happy to find people who are older than me in the audience as well. So it was born out of the 42nd Constitutional Amendment, which was, one of the objects was to combat the delays and backlogs which were faced by our courts. It was hoped that these tribunals, which were untethered by the strict rules of evidence and procedure, would help unclog the courts and aid overall in the dispensation of justice. The Central Administrative Tribunal has grown multifold since its establishment. As Justice More just told us, 19 benches and 19 circuit benches across India, with approximately 9 lakh cases which have been instituted. Most of these cases, I must add, have been successfully disposed of, which is a unique achievement for a tribunal, because our tribunals by and large are plagued with problems. And then we ask ourselves, was it really necessary to constitute so many tribunals? Because you don't get judges. When you get judges, vacancies arise which are kept pending for a long period of time. And there is this constant tussle about who will have ultimate control over the appointment of judges. Then again, initially it was postulated that appeals from the Central Administrative Tribunal would come directly to the Supreme Court, which meant that somebody who has been suspended or someone who was transferred from station A to station B and whose spouse was suffering from a terminal disease had to come all the way to the Supreme Court against an order of the Central Administrative Tribunal. That was replaced, of course, after the Supreme Court held that the writ jurisdiction of the High Courts will not be excluded. In the Bombay High Court, we have a particular affinity to the Central Administrative Tribunal because two of our own colleagues have risen to become chairpersons of the tribunal. Justice Ashok Agarwal, who was such a fond member of our bar and bench, and now Justice Ranjit More. Both judicial and administrative members have complemented the work of the Central Administrative Tribunal. As I was just speaking to Justice More a short while ago, we judicial members, our knowledge is by and large based on books, on service law, and our experiences in conducting litigation for our own clients. But the administrative members have a real feel for grassroots reality in the service of the central and the state governments. So this combination of the judicial and administrative members has really strengthened the Central Administrative Tribunal by bringing together the wide experience in litigation of the judicial members. Many of them have wide experiences, members of the district judiciary. They bring a sense of continuity. And you have the administrative members who have a real understanding, an understanding of the difficulties which people who are in service face. So from being effective alternate substitutes to the high courts, the tribunals came to be recognized as supplements to the functioning of the other courts. The tribunals have assisted courts of the country by redirecting service matters, among others, towards themselves. But this is not all. The tribunal has afforded a shorter route to certain categories of litigants. A longer legal battle is bound to become more onerous, perhaps more for one party than the other. The delays in litigation always tends to impact one party more than the other to a dispute, regardless of the individual merit of the case. For instance, a rightful but weary pensioner or a wrongly terminated single mother may not withstand a long and winded litigation, as well as outlast her much more powerful opponent, usually the state, in a long winded legal tussle. She may continue to have both the substantive right and the right to enforce it, but the prospect of a prohibitively long and costly legal battle may stifle the right at the very outset or overshadow the right in the course of the journey. So the very existence of administrative tribunals is premised on their ability to make this journey less onerous for litigants in matters of public employment, which I believe that they have. Recently, we held a conference of all the Chief Justices of the High Courts on the occasion of the Constitution Day, when we set up the statue of Dr. Babasaheb Bhimrao Ambedkar in the precincts of the Supreme Court. A report was prepared by the Center for Research and Planning of the Supreme Court called The State of the Judiciary. And this report highlights the infrastructural gaps in the judiciary. The report found that for the sanctioned strength of 25,081 judges in the district judiciary, there is a shortage of 4,250 courtrooms. and 6,021 residential units. Notably, 42.9% of the total courtrooms have been under construction for more than 3 years. In contrast to that, this new building of CAT, the 2 floors, represents our continued efforts to work towards more inclusive, accessible and just institutions. While accessible institutions are a goal in themselves, they are also a means to a goal, a means to an end. We know that the barriers that stand in the way of access are many. Social barriers, physical barriers, or systemic barriers. The purpose of the infrastructure of our institutions should be to mitigate these barriers for a meritorious legal dispute to be heard. For instance, the inability to get a timely outcome may impact the practice of a male as well as a female lawyer. Everything else being equal, in a society that associates intellect and caliber with gender, the impact of delay will be greater for the woman lawyer than for a male lawyer. She is not only fighting her immediate opponent in court, who perhaps benefits from the delay, but is also combating years of gendered perceptions about her innate ability to be a lawyer, a profession often incorrectly linked with unemotional rationality, not typically attributed to her gender. A delayed delivery of outcomes would weigh much more heavily on her than it does on her male colleagues. Similarly, the impact of professional losses due to the delays and costs of litigation is more pronounced on a lawyer who is a first-generation lawyer than it is on others who have the safety cushion of a generation social and financial capital. The identical, facially neutral problem of delay could have disparate impacts on different people. At a certain level, we feel that delay affects everyone equally, but that is not so. It's facially neutral, but it has a disparate impact on different people for reasons rooted in social barriers rather than merit. Accessible institutions can in many ways level social and other imbalances by accounting for such social and other barriers. Women, however, have been performing against all odds in the legal profession in India, and Maharashtra is no exception. The State of the Judiciary report found that out of 16 states which recently conducted the Civil Judge Junior Division recruitment process, 14 states had more than 50% selection of women judicial officers. In some states, even in the absence of a horizontal 30% reservation, the number of women who are being recruited at the lowest level of the Indian judiciary has gone up to 70 or 80%. Therefore, our processes and infrastructure need to be architecturally inclusive to address the challenges as well as the changing composition of the legal profession. Look around you today. When I was at the bar, you wouldn't have this large presence of women lawyers in any auditorium. But that has changed. And I do believe that tribunals like the Central Administrative Tribunal, apart from the fact that they render justice and service matters, have a very vital role to play in the development of our own bar, in creating more opportunities for argument, which are not necessarily available in the superior courts. This lies at the very core of reasonable accommodation, which runs through the fundamental rights which are guaranteed by our Constitution. In the context of rights of persons with disabilities, we have reiterated that the freedoms and the right to life will ring hollow if they are not given additional support that helps make these rights real and meaningful for them. I remember just a few years ago, there was a judgment which said that becoming a judge is not something which is open to a visually challenged person, a blind person. That judgment was reversed several years later, but have we created adequate opportunities for the visually or the physically challenged to access our court spaces? As courts and tribunals, we cannot immediately wipe out the impact of these inequalities in our society. We must, however, strive to bridge the gap between people across the spectrum of inequality as far as legal outcomes and processes are concerned. One way of doing that is to ensure that our infrastructure is inclusive and affords the requisite support systems. I was therefore very happy to learn from Justice Ranjit More's brief address of the rapid steps which have been taken by CAT in ensuring that technology is incorporated in the system. Physical infrastructure can include many things that go beyond the four walls and roof of a courthouse, such as the judge's bench, podiums for lawyers, witness boxes, judges' chambers, registry, and other offices. Years ago, and I'm not talking of 3 decades ago, just a few years ago, when Justice Abhay Oak and I were administrative judges for Kolhapur, Justice Oak and I visited Kolhapur to inspect the infrastructure, and we were told that there was no bathroom in the district court for women judges. And there was a very senior additional district judge who said that, sir, there are women here today who are 28 or 30. They come early morning. They can't go to the only toilet which is earmarked for women because they have to pass all the under trials. So they say we find it extremely because they jeer at us, they look at us. Next visit to the bathroom is at 6 o'clock in the evening when they go home. That was the reality of even a developed state, as we call our own state, the state of Maharashtra. So this is something which we really need to look at. Accessibility includes features to enable access and maneuverability, such as ramps for the disabled, elevators, and signages in different languages. I understand that in cities like Mumbai, it is very difficult to remodel courtrooms to make them accessible to the disabled. But surely the conversation must begin, however difficult it is to achieve the desired outcome. A report in 2018 has surveyed the state of infrastructure of courts and found that there were significant physical infrastructural gaps in the availability of ramps, lifts, waiting areas, help desks. The Supreme Court Center for Policy Research report just published last month has found that only 13.1% of the district court complexes had childcare rooms. Only 50% had ramps with persons for disabilities. The report found that 40% of courts had dedicated places for persons with disability, and only 30% had infrastructural support in form of tactile paving. Recently, I had requested Justice Devendra of the Supreme Court to chair the Accessibility Committee. The report of the Accessibility Committee of the Supreme Court of India highlighted the issues faced by persons with disabilities, women, particularly during pregnancies, as well as senior citizens in accessing courts physically or digitally. Most of the people who will come here in search of pensions are senior citizens who have lost their employment, who have retired. The committee has provided a series of actionable recommendations: accessible route maps, pathways, accessibility of documents, regular updates on fresh matters, assistive technology to navigate the court website, and various other accessibility improvements across court complexes. Let me briefly speak about technology, which is very close to my heart. Technology must foster the relationship that litigants share with courts. However, we must remember that it can never become a condition in accessing justice, the sole medium to access courts. Physical access to courts can never be understated in its importance and must be constantly improved. It is no answer to a wheelchair-using litigant, a senior citizen, or a lactating mother for our courts to tell them that our courts are better experienced online. The gains of such state-of-the-art technology must supplement and not sabotage physical access. The litigant alone must have the choice of how they want to access the courts. Our function as courts and tribunals is to give them an effective choice between a fully functional and accessible physical court complex and an equally efficient technology-enabled court. As the old saying goes, justice must not only be done, but it must be seen to be done. As institutions founded upon public faith, our infrastructural advances must be guided by the objective of accommodating people with diverse needs from diverse segments of our society. Enhancing the quality of the infrastructure of an institution also influences public perception and trust in our work. Well-maintained and accessible infrastructure can enhance the public's confidence in the state's ability to meet not only their legal needs, but also account for their comfort as they navigate through the complexities of these daunting legal journeys. A very distinguished Japanese architect who redesigned the Museum of Modern Art in New York said, "Architecture is basically a container of something." I hope that they will enjoy not so much the teacup, but the tea as well. As members of the bar and the bench, I take the liberty to speak for all of us when I admit that our collective limits in the understanding of architecture are for all of us to see. But we are equally united in our spirit of service. A conversation about infrastructure is incomplete without a tip to a very crucial component of our courts, the people who navigate the other two physical and digital components. I know of many lawyers who would not shy away from going above and beyond in the discharge of their professional duties. I similarly know many of the judges who work tirelessly to leave their courts better than how they found them, and that includes all the former members of the High Court who are here. They have dedicated their life to the mission of serving the cause of justice, when they could have spent their lives earning tons and tons of rewards that lie outside in the profession. So it is not just in terms of their jurisprudence that the judges have contributed, but also in terms of their institutional legacy, which goes beyond the case law which they have contributed to. We have in many ways come to redefine justice in terms of accessibility, in addition to its principled outcomes. As a court of precedent and sometimes as legal scholars, we do indeed stand on the shoulders of our own colleagues, ancestors in the judiciary who preceded us. The court's personnel infrastructure comprises not only of our lawyers and judges, but also our registries, support staff at all levels of courts form the basic or the backbone of our system. The Supreme Court of India, we have launched upon a calendar for training the entirety of our staff. So it is important that we train our staff. We must help them aspire for career advancements. Their efforts often go unseen by the public eye, but I must say that many cogs of the machinery of our courts must fall right into place as they do for them to run smoothly. Courts, tribunals, and every single person who works towards improving them essentially function as the vessels of justice. We are not just the container, but also what lies inside the container. For facilitating and fostering social cohesion by addressing grievances and disputes across diverse segments of our society. Sometimes in states like Maharashtra, we do not realize the importance of the work which we as judges do in this institution of justice. Having spent now the last 11 years in a place outside my own home state, initially in Uttar Pradesh, now in Delhi, and looking at the entirety of a nation, I realized how blessed we were as lawyers, how lucky we were as judges to be able to do our work in such relative objectivity. As judges, we had a bar which was so professional. I always say that the hallmark of the Mumbai bar in particular, and that's across Maharashtra, is that the lawyers before us don't bother about how you decide a case. All that they care is that you decide the case. Please don't duck the case. If they have a problem, they can go in appeal. We used to say in the Bombay High Court, if I had a problem before a single judge, we went onto the second floor and got a stay the next day. But that is really, truly the beauty of this state. And I think we should not ever ignore the favorable conditions in which we work as opposed to the rest of the country. There is also a culture of governance in the country where governments successfully have left the judiciary alone. They don't tinker with the work the judges do. They accept outcomes which are favorable, they accept outcomes which are unfavorable, because that is the culture of Maharashtra. That's something which we must, as individual citizens, be proud of in the work which we continue to do. The office complex that we inaugurate today is named Nishtha, which loosely translates to faith, a sentiment I am sure it will reflect in its functioning. I am certain that it will serve as an effective vessel in discharging the functions of the Central Administrative Tribunal, Mumbai, and will enhance greater access to the tribunal.